bear with us as we try to walk through the changes to the bill.
Well, thank you, Senator Sears. For the record, my name is Ben Novogrodsky from the Office of Legislative Counsel. Before I get into the bill, I just want to let the committee know that I do have some clarifying testimony on S-196 that I can either do now or postpone.
Weight of evidence. Yeah, why don't we wait till we get there?
Okay.
I was hoping to fold it into the bill.
Okay.
Or let it stand alone if Senator Machine.
We can, yeah, let's see how today
Let's go through this one first.
Sure. So I'll highlight the changes from the incomplete version that was walked through last time. So you'll see here in section 1, previously in lines 20 and 21, the language except as provided by into subdivision 2 of the section of the subsection that was struck. This was after conferring with the prosecutors that this would remove a level of discretion, basically for prosecutors to have when it comes to citations or arrest. And so they, even though it was initially suggested by them, I think that they are reconsidering that. So that strike through has been removed. But the $200 cap on when it comes to expungable misdemeanors is still removed for those that have been for those who commit a new offense upon release. So that still remains. Outside of some gender neutral changes that were in the last version, the next big portion of changes, and again, I'll just highlight this portion here was in the last version, so I'll just bypass it for now. But scrolling through to page 10, which is the home detention portion of the bill.
Okay.
So home detention has now been revised. So it's no longer only individuals who can't make bail and have been held for 7 days, which is the current eligibility requirement. That requirement has been changed. So now it would be available at the request of the court, the prosecutor, or the defendant for any person charged with a violation of conditions of release pursuant to section 7554E, which is the new violations of conditions procedure, which I'll go through, or 7559. 7559 is the current mechanism to enforce a violations of condition of release. And in the previous version, it was repealed. It is no longer repealed. That was at the request of the prosecutors as well, basically to make sure that the new mechanism works without removing the old mechanism first.
And since we crossed out the Department of Corrections on line 12, should we put in the Department of Corrections rather than just the department on line 19?
Yeah, that's probably a good change to make sure that there's no confusion, and also a strike through that made it through that should not be here is on lines 21 and on the line 1 and 2. Yes, that was just a mistake from the last version that it should not have been struck. So my apologies there. But you'll see, again, this change in language is just to reflect the actual words of the definition, rather than assuring court appearance. It's just to mitigate the defendant's risk of flight. You'll see here in subsection C, the department had initially had the power to revoke the defendant's home detention status for an unauthorized absence or failure to comply, and could return the person to the facility. Given the change of eligibility, in order to do that, that would now have to go through the bail revocation statute under 7575. So that provides more process for someone who violates to go through the bail revocation statute, and the very high standard is to revoke bail altogether and return them to incarceration. And then subsection E is program support, and this permits the department to contract with any public or private entity that meets the requirements to assist in supporting the program. Section 4 is a complete revision of the new proposed 7554E violations and conditions of release. You'll see subsection A outlines the procedure. It requires notice to the defendant in a hearing to determine if a condition of release was violated. It still retains the language from the last version, allowing someone to be arrested or cited in accordance with Rule 3 to appear before the court in which the conditions of order were released. It authorizes a judicial officer to issue a warrant for the person charged with the violation, and then the person must appear not later than the next business day following the arrest or citation, and then it permits a hearing at that appearance. The standard of proof, or burden of proof rather, is a preponderance of the evidence.
That a violation occurred.
This is if a violation occurred, yes. This is the process to determine if the violation is found. It's a preponderance of the evidence standard to prove the violation that is greater than a probable cause standard, which for most new crimes is the probable cause standard, but it's elevated in this case, given that there's case law that says when a violation of condition that also could amount to a new crime because of the liberty interests involved, basically the probable cause standard is helps strike a better balance between finding that probable cause standard and putting someone through the adjudicative process, or preserving balancing that with the liberty interests involved. So that's why it's present here. The hearing, there are various considerations that the court must weigh in determining if a condition was violated. One is whether the violated condition does not otherwise constitute a new crime, whether the violation does otherwise constitute a new crime, the nature of the underlying offense for which the defendant's charged, basically the person's history, prior convictions, history of violence, mental health needs, history of supervision, and risk of flight, and any risk that the person poses to the public.
How does the court determine that?
The last portion, and
Yeah,
the risk
to the public.
Well, I think
History, the criminal record, or?
it could be their criminal record. It could be, I mean, in this circumstance, it would be, they're already talking about a violation. So if that violation itself was connected to a condition that was, let's say a no contact order or something like that, that might speak to the risk that that person poses if they violated that specific condition.
Okay. So the public doesn't necessarily mean the general public. It could mean a specific individual.
Correct, in this context.
Victim of domestic violence.
Correct.
That's helpful.
The evidentiary standard is similar to the other bail statutes with the exception. So it does not need to conform to the rules of evidence. However, this provides, you'll see on 17 and 18, judicial discretion to bring in live testimony if the judge deems it necessary. That's just to essentially, there's sort of in this line of cases, since this is technically still within pretrial release, and as 196 was discussing yesterday, there's an effort to sort of make uniform the evidentiary standards, in that this is balanced with the substantial and admissible evidence standard that we discussed yesterday, which could bring in live testimony if it's deemed necessary by the court. So it gives the court discretion to get more reliable evidence if it feels necessary to find a violation. Then subdivision 3 empowers the court to issue an order. The order can be one of various things. So one, upon a finding that the person violated conditions of release, the judicial officer shall issue any of the following orders to reasonably ensure the person's court appearances, to mitigate the person's risk of flight from prosecution, or to reasonably protect the public. So those are the three bases that the court can use to impose further conditions. One is to impose any condition or combination of conditions pursuant to section 7554 of this title. That's the bail statute. The language here in 7554, it mandates that it must be the least restrictive condition or combination of conditions. If there is a finding that someone violated, it removes that least restrictive language. So it can be any combination under 7554. The court could also place the person under the supervision of the pretrial supervision program, which I'll get into, under the auspices of the DOC. It may place the person in a program of community-based electronic monitoring, which is the GPS program, which I'll get into, but that's largely unchanged from the last version. Or it could place the person in the home detention program pursuant to subsection 7554B. So those are the list of potential conditions that can be imposed if and only if someone is found to have violated a condition of release. In subdivision 2, if the person who violates the condition of release and it also constitutes a new crime and the judicial officer feels it may be necessary to revoke bail altogether, they have the discretion to do that, but it must be pursuant to the bail revocation statute in 7575, which is a very high standard to do. And I'll get into that. Okay. Subsection E explains that this is an exclusive remedy. That essentially there is an exclusive remedy. The prosecution must choose between this section or the 7559 VCR mechanism that's already in existence. They can't do both. And so it shall be a prosecutor's exclusive remedy to modify or supplement conditions of release as a result of an alleged violation, but this preserves the court and the prosecutor's discretion to hold someone in contempt for any other reason other than a violation of conditions of release. I can get into the electronic monitoring program, but it's not any different since the last version of the bill.
No, I think we all understand that what we're going to do there, unless there's some questions about it.
And then we'll get into, on page 17, the pretrial supervision program.
Right.
So under this new statute, the purpose of the program is to assist eligible people through the use of evidence-based strategies to improve pretrial compliance with conditions of release, to coordinate and support the provision of pretrial services when appropriate, to ensure attendance at court proceedings, and to decrease the potential to recidivate while awaiting trial. There's a definition here of absconding that's used here. It's just a cross-reference to make sure that it's meant, the meaning stays consistent. But pretrial supervision.
I want to make a point that what Ben and I talked about was, rather than having everybody who comes under conditions of release be automatically supervised, that only be people who violate conditions of release. So if you have not, if you're, and I would assume the vast majority of people that are let out on conditions of release don't violate. We obviously hear about those that violate. So the only ones that would come under supervision, if the court so chose, would be those who have violated a condition of release. Correct. So it's a alternative. You can call it a sanction, call it whatever you want, but
it's almost like graduated sanction.
Yeah, no, I certainly appreciate the want to limit that, but I wonder if this language allows the court to make the decision that someone might benefit from those pretrial supports and services before they violated, that it might help them.
It doesn't.
Yeah, okay. So I
doesn't contemplate that.
Yeah, I do want to make sure that we don't send everyone, but I don't want to wait for someone who might really benefit from those supports and services. I don't want to wait for them to fail. So I would love to have language in here that would allow one of the conditions before they violate to be that they.
Yeah, I think one of the considerations here is that there was testimony from the Department of Corrections about capacity as well. So I think that this was a policy decision to balance that with the goal, one of the goals, you know, that the goal that you state being one of the goals of the program itself, but to limit the
senatorship
program.
I was just going to echo what you said, Ben, regarding DOC capacity, and I think, yeah, it would be great to have this apply more broadly, but I think with the way it's written, having it apply to folks who are more at risk of reoffending because they've already reoffended, I think makes sense.
I have to say I disagree. I don't want to wait for people to fail in order to get them the supports and services that they need to succeed.
I think that trying to create a program that exceeds capacity for DOC and would thus cause people to fall through the cracks could present some real challenges for the folks who are being supervised.
People that are supervised sometimes are more likely to get caught for minor stuff, and that's.
So Senator Sears, if I may ask a question, when you say the supports and services, what are?
So one of my understandings of how we were setting up this program was to really help people succeed, help people not violate conditions, help people access the services that they needed. And if we are identifying someone as we're setting conditions of release that could really use help navigating that, I think it should be available to them before they violate.
Well, some of the services that this does not affect are the pretrial services that are already offered at outset. So as far as, substance use, screenings and things like that, that is still can be done at arraignment in the normal course as it's currently done now.
No, I understand that. And it's, I think for people right now, not providing them the level of navigational support that they might need. And so if we're working on trying to use this as a means of allowing fewer people to be held because they can't pay bail, then I think it should be available to people before they make a mistake or they fail to meet the conditions of release. And again, I don't think it's for everyone, but I think the court should be able to set it for people that it's like, this would be really helpful for this person.
And this isn't just for people that can't pay.
No, I understand.
Okay, I just wanted to.
I just know that one of the conversation points in the committee has been around bail and creating this system so that bail is perhaps not used as much.
Clarifying question. So if somebody has their conditions and they don't necessarily violate them, but they have a history of non-appearance, I'm looking at subsection 1 under pretrial supervision on page 17. So if they've been given these new set of conditions, but in their history they've repeatedly not appeared at court, would they still be eligible for the pretrial supervision?
Only if they were found to have violated.
They will.
So yes, and those are the two, it's 7559 or 7554E. Those are basically the pathways to get to this consideration.
It doesn't mean they couldn't be placed in home detention, doesn't mean they couldn't be placed in other.
Well, right, but the home detention program and the GPS monitoring, those are, again, all dependent on a violation.
Right.
So if they violate, then there's that sort of menu of escalated
What
sanctions.
we're trying to do is set up alternatives to hold people accountable that may not want being returned to jail or.
Right. So just going on, so subsection C really just kind of describes the program of itself, that it's designed to supervise people who violate those conditions and who pose a risk of non-appearance, risk of flight, or to public safety. DOC is responsible for supervising the defendants placed in the program. The department shall assign a pretrial supervisor to monitor supervisees in an assigned region of Vermont and help coordinate any pretrial services needed by the supervisee. So that's one of the responsibilities of the supervisors, that the person does need some pretrial services, they can help pair them as well. The department shall determine the appropriate level of supervision based on evidence-based screenings of those persons eligible to be placed in the program. And there several supervision methods. One, the department can use the department's telephone monitoring system, which my understanding is essentially an automated system that can be used to remind people of court appearances or of meetings with their supervisor. They can also have telephonic meetings with their supervisor, in-person meetings with their supervisor, or any other means of contact deemed appropriate. That's sort of a catch-all that if there's some other form, like for instance, in the North Dakota program, they utilize FaceTime and Zoom meetings. This could essentially cover that, but given the connectivity issues that are experienced throughout our state, mandating that as a form of supervision just didn't seem prudent, but can be done if the committee feels otherwise.
So I recognize that that's a list of things that the department may use, but I noticed in line 1, it says they shall use them. Is that correct?
Yes.
Or should it be may?
So they have they must use one of these.
Okay.
Because that's how they supervise. So, pretrial supervisors shall notify the court that place the person in the pretrial supervision of any violations of supervision requirements committed by the person. The court may issue a warrant for the arrest of the person who fails to report to the pretrial supervisor, commits multiple violations of supervision requirements, or is suspected of absconding. And the person shall appear before the court for a bail revocation proceeding pursuant to section 7575 of this title. So that's what happens if someone violates it to such a degree that they fail to report, they commit multiple violations of requirements, or absconding, meaning that they've essentially fled. If they can be found, they appear report for a bail revocation hearing. So the procedure for these hearings: the court, the prosecutor, or the defendant may request that a person be reviewed by the court to determine whether they are appropriate for pretrial supervision. The review shall be scheduled upon the court's receipt of a report from the Department of Corrections determining that the person is eligible for pretrial supervision. This is similar to the home detention process that plays out now. And a person held without bail pursuant to 7553 or 7553A shall not be eligible for pretrial supervision. A person who is eligible for supervision if A, they have violated the conditions of release pursuant to those two enforcement mechanisms, they are a Vermont resident with a Vermont address, and they have the ability to make or receive telephone calls. After a hearing, the court may order that the defendant be released to the pretrial.
Just on C, that's a little sketchy, because if all they have is cell phone, and I think now with the loss of landlines, most people, that's all they have. And in some places in Vermont, you still can't get cell phone coverage. That shouldn't disqualify somebody. They probably could get cell phone coverage at the local library or wherever, but they may not have it readily available. And I'm just wondering if that's overly,
Yeah, and then that's, I think, a policy decision. The reason why it was chosen here was talking to the department, that was one of the things they felt was necessary. And also this sort of mirrors the home detention program to a degree.
When I'm driving home from Bennington, or driving up here from Bennington to Montpelier or vice versa round trip, I have certain areas where I lose any cell phone service. So one could say I don't have the ability to make or receive telephone calls at certain. If people want to talk to me, I try to estimate when I'll be in certain towns so that they can call me at a certain time, so I'm not in the dead zone. And it's really surprising how much of it there is between here and Bennington. So I really think we should revise that somehow revise that, so that just because they have the ability to make phone calls, but not on a. I'd hate to have somebody denied this because they couldn't make a phone call at their home, and they had to, even in my house, sometimes I have to go outside to make the phone call.
Yeah, well, that's obviously the prerogative of the committee, so that can be something that can be changed. Just to explain.
Just flagging that to be something that I think we should be more permissive to the court to establish whether or not they have the ability to.
Mhm. Okay, I'll mark that down. So after the hearing, the court may order the defendant released to the program, provided the court finds placing the person will reasonably ensure the person's appearance, mitigate the risk of flight, or reasonably ensure protection of the public. In making such a determination, the court must consider the nature of the violation of conditions of release pursuant to those enforcement mechanisms, nature and circumstances of the underlying offense for which the person is charged, the person's prior conviction, history of violence, those other things, and any other factors that the court deems appropriate. As far as compliance with the requirements of the home detention program, or excuse me, of the pretrial supervision program, a person who complies with all the requirements for not less than 90 days may receive a reduction in their supervision level, or someone who violates a requirement may receive an increase in the supervision level. And so that is the new statute for the pretrial supervision program, if there are any other questions.
Yeah.
Okay, and then as far as the bail revocation statute, this has really just been built out to reflect case law. So you'll see here outside of the heading, subsection heading titles, in subdivision 2, it changes by striking out impedes to disrupts. That reflects the Solve case, or Sauve, however it's pronounced. I'll defer to Judge Sone on the pronunciation. So it mirrors that language, which arguably is a lesser standard than impediment. And then you'll see there's a new subsection B, which talks about hearing being required and the burden of proof. And the court may revoke bail only after notice to the defendant in a hearing. The state shall have the burden of proving by a preponderance of the evidence that the accused engaged in the conduct identified in those previous subdivisions of subsection A. There's an evidentiary standard. To meet its burden, the state must present substantial admissible evidence sufficient to fairly and reasonably convince a fact finder beyond a reasonable doubt that the accused is guilty. Evidence only showing that the accused may endanger the public is insufficient to meet the burden. That's coming from case law itself. And then orders of the court. A court may only revoke bail upon a finding that a legitimate and compelling state interest exists to revoke bail. The court shall not revoke bail based on a breach of conditions of release alone or solely because the accused may endanger the public.
Let me ask, and I realize this is an outlier.
Yes.
I think everybody got a thing from the Department of Public Safety yesterday about a guy named Michael P. Reynolds. Mr. Reynolds has more than 1,600 total police engagements dating back to 2012. Nearly 1,400 of those took place in Burlington. This is a greater number of engagements than any other individual in the Valcourt Records Management System. He has had more than 30 engagements in 2024 alone. Over the past several years, he's been trespassed from nearly 150 locations in the Queen City. Mr. Reynolds' criminal history includes, but is not limited to 10 failures to appear, 39 charges, and 3 convictions for violation of court orders or conditions, 19 charges and 6 convictions for various felonies, 162 charges and 42 convictions for various misdemeanors, 32 charges and 13 convictions for assaultive crimes. The police brought Mr. Reynolds to arraignment. The court released him on conditions. That's, quite frankly, what has the public upset, and I don't blame them when they see cases like that. I realize that this is probably an outlier. Obviously, he reminds me of $1 Million Murray in Reno, Nevada, who had a very similar record history, and then they determined that he was costing the city of Reno over $1 million a year just to do things, and so they decided to put money behind and get him all kinds of services. Anyway, beyond the fact, this is what, and I want to know if this would address Mr. Reynolds. I don't understand. I mean, I realize we can't talk Judge Zone can't talk about specific cases. But I think the public has no clue of why somebody with this record would have been released on conditions following an arraignment.
Well, the reason why is because constitutionally, everybody is bailable in Vermont. So everybody is presumed to be released, and that can be on conditions. What this bill attempts to do is to have more accountability for those repeated violations that someone like the person you just mentioned have committed. So they could be brought in again, and then these essentially escalated sanctions, for lack of a better term, could be imposed: home detention, supervision, GPS monitoring, or more conditions under 7554. It also gives the court the discretion to revoke bail altogether, as long as they follow the bail revocation statute. But that doesn't preclude the prosecutor from just using that statute as well.
But I think it's important, whoever reports this bill, if they have that statement in writing about the Constitution. But that wasn't what, a lot of people are still disagreeing with what the 1992 change in the Constitution meant in terms of public safety. The courts have ruled since 1992, I believe, that the constitutionality, everyone's bailable. But I don't know that that was what was intended by the legislature when they did the constitutional amendment. That was an argument that went on in 1993 in this committee. This committee, which I became a member of, but obviously wasn't a member of when they drafted the constitutional amendment, believed that they had in there protecting public safety was also a factor, which somehow that's not how the courts have ruled. That's my understanding. And if I'm overstating or understating or whatever, but that's where the disconnect comes in. And it started in 1993 in this committee. Obviously, we can't go back to the records because we didn't have computers in 93 and we didn't have YouTube to record what was being said. But that, John Bloomer Sr. sat here in this chair. Vince Saluzzi was over there. Jan Backus was over there. And I was sitting where Senator Bahowski is, being a quiet little fresh person, and had no idea what the hell they were talking about. But it really boiled down to, they believed their intent was public safety would be a factor under the Constitution.
Well,
and the court ruled differently in 93, and that's where we are. So, you know, it was an interesting conversation in here. I can't remember the sixth one. We had 6 members then. But it goes back that far.
and I guess just to clarify too, I mean, public safety cannot be the sole legitimate use of bail. You know, and that's, yeah.
It's not debatable because of the court has the final arbitrary of what's constitutional, what's not. We don't get to do that. But it's, the legislative intent was different back in 92. It actually was, well, it had to go through the process. It was voted on by the public in 92. It became effective in 93.
Do you want me to continue on? Or?
Yeah, Margaret Luceni sat over there with a typewriter. Charlie Bristow had bills in front of him and he was writing things up.
Right.
Vince Saluzzi was sitting over there and writing things in red ink and handed to Charlie. Charlie'd have to go over to Ledge Council. They had no computers.
Different time.
Different time.
Oh.
Everything was tape recorded,
You could probably pull those tapes and,
I bet they're still in the archives.
probably somewhere.
yeah.
Very different, Ben.
Yeah. So just finishing up with subsection D in 75, excuse me. So the court shall not revoke bail based on a breach of conditions of release alone or solely based because the accused may endanger the public. There has to be more than just that. And in any order revoking bail, the court shall make a specific finding that the state met its burden pursuant to subsection C of this section. Again, this is really just to mirror that case law. The definition under 75-76 is unchanged from the last version. There's still the addition of any violations of conditions of release by the defendant that was added to sentencing alternatives consideration. And then in section 10, 18 VSA 4253, there is a change from the last version where for the purpose of this section, use of a firearm includes using a firearm while selling or trafficking a regulated drug. Before, it had initially read carrying, possessing, or using, and then it was changed to just carrying, and now it's just using. And this is after conferring with Eric on creating some consistency with some of the gun bills that are related. So it would be actual use of the firearm while engaged in selling or trafficking. And then subsection D is the same as the last version, but it would just be conduct constituting the offense of using a firearm while selling or trafficking a regulated drug. It used to include dispensing. Dispensing was removed to not unintentionally broaden it. In section 11 is the DOC appropriation.
I'm sorry, Ben, before you leave that, it says selling or trafficking. I'm just, trafficking being, how distinguished from selling?
I'd have to check the statutory definition, but it would be like, yeah, I think it's
different amount.
Just amounts.
Okay.
Yeah.
There's, we set up,
it's in the
selling
statute.
is a small, obviously a smaller amount, trafficking is a larger amount, it depends on the drug.
Okay.
But
Yeah, it's just confusing when you're thinking about human trafficking.
Right.
Yeah. But anyway.
Yeah.
I think, like, for example, marijuana, it's still illegal to traffic marijuana, and I think it's 50 pounds.
That's a lot.
Yeah. That kind of fits in your backpack.
Right. And then dispensing itself was removed so that it wasn't someone that was just providing to someone else. You actually have to be engaged in some affirmative activity like selling or trafficking. So, any other questions on that portion? So section 11 creates the appropriation for the new positions within DOC. So it would create 6 new permanent classified pretrial supervisor positions within DOC. In addition to the duties deemed appropriate by the department, pretrial supervisors shall monitor and supervise persons placed in the program pursuant to the applicable statute. They're subject to a general fund appropriation in FY25, and then there'll also be 1 new administrative assistant position to support the new program as well. Section 12 creates a new misdemeanor offenses docket within the judiciary. It reads that the intent of the General Assembly to create a misdemeanor offenses docket within the criminal division of the Vermont Superior Court to help address the current court backlog and expedite resolution and adjudication of misdemeanor cases. On or before January 1st of 2025, the Vermont Judiciary shall create a misdemeanor offenses docket within the criminal division, and then prior to the creation of the docket, the court administrator shall adopt policies and procedures to effectively administer it. And then the date, it's effective upon passage.
That's great. I'm gonna ask if we can actually constitutionally do section 12.
Eric and I discussed this, and
Do section 1, did you say?
Section 12,
Section
the creation of the docket.
I don't think we're allowed to tell
Right.
other branches.
And
I was
what to do.
wondering about that as well.
there has been intent language in the past to create, like for instance, I think a special DUI docket.
Okay.
But where we kind of settled is that, you know, there's the overlapping, you know, separation of powers between the two branches. Rather than saying you must assign a judge to a docket, we felt it was more,
We're advising them to do it, but if they don't do it, there's nothing we can do.
right, yeah. I mean, it's a mandate for them to do it, but there's nothing.
Well, it's our intent, but it's not
Here's a mandate.
Yeah, I mean,
Section
it does
Yeah.
require them,
mandate.
but it doesn't tell the judiciary exactly how to administer.
Well,
it.
we'll hear from Judge Zone on that, but you do want to raise that it may.
And the issue is valid, you know, it's
I will say this came directly from the Attorney General's office, the head of the criminal division, who would like to see this.
but after the discussions, we felt that it was more of an overlap rather than usurping
Okay.
the judiciary to say, create the docket, however you want to do it is up to you, but you just must create the docket.
Well, Senator Norris.
Yeah, just some clarification, Ben. I may be reading this wrong. Under section 11C, says one new permanent classified administrative assistant, and it goes down through, that's one position, correct?
Correct.
If I go to page 25, under line 1, the two administrative assistants established in subsection.
Yeah, it should just be written, that was just an
Just one,
oversight.
okay, thank you.
Okay, good.
Just save us hundreds of thousands of dollars.
Tell you what, you're welcome.
So that's the bill.
That's the bill.
Now, the bill, because of what we've seen and what we're trying to do, is focused, it's a combination of the bills introduced by Senator Brock, Senator Norris, and others, Senator Caldmore. But it focuses on violations, conditions of release rather than necessarily on bail. And the reason for focusing on violations and conditions of release, after getting into this committee believed that that's where the problem is. And it's not with the thousands of people who are released yearly on conditions of release who you never heard of. It's those that continually violate those conditions, and that's what the code is upset with. So hopefully helps to address that, but that's the basis of the changes rather than looking at bail itself. Ben, thank you for the hard work and good work on this, and I know I've been through a number of redrafts and relooks, and we appreciate your hard, steady work.
Would it be okay to address the 196 testimony now, or should I continue? I can still postpone.
I mean, I don't know if we
Yeah, we're
for
falling behind here.
Okay.
I think we can come to that.
I can do that another time.
So let's hear from. Agenda.
No, Marshall first.
Marshall Paul. Okay.
You can, bring that chair.
No witnesses must sit on the floor today.
Good morning, and thank you for the opportunity to comment on S-195. Marshall Paul from the Office of the Defender General. And I'll just jump into it because I know we're running a little behind and our comments are fairly extensive. So I'm gonna start with, I'm going to just go through this sort of section by section. And I'm gonna start with, on page 2, some concerns we have about lines 12 through 14. What this really does is it links the use of cash bail to the question of whether someone has committed an offense. That's unconstitutional because cash bail can only be used to ensure appearance in court. So if this provision said something like, for example, the $200 limit shall not apply to a defendant who has fled to avoid prosecution, that would be constitutional because you would be tying cash bail to appearance in court. But where you tie cash bail to commission of further offenses or public safety, that's outside of what the Constitution allows. So from our perspective, that provision is completely unconstitutional. That gets us to page 10. And on page 10, we have lines 11 through 16. And this is the provision that makes changes to eligibility to the home detention program. And it does a couple things that we have concerns with. One is that it eliminates eligibility for the home detention program for people who are incarcerated only because they cannot pay bail, which is a small group of people. I'll acknowledge that right from the beginning. The home detention program does not serve very many people in its current status, but at the same time, the group that it serves is an important group. That is people who would spend a lengthy period of time incarcerated only for their lack of cash to pay bail. And we don't think that it should be limited in that way. We think that home detention should still be available to those people.
I just want to clarify, you mean that it's a small group, number of people that are utilizing the home detention program, not that it is a small number of people in jail because they can't
Yes.
pay bail? Okay, because I was like, last time I checked, that was over 200 people.
No, it's a small number of people who are on home detention. I think last time I checked, it was 11.
Got it.
I
I just wanted to clarify.
We also have concerns.
Can I ask before we move on?
Sure.
Ben, can you tell us about the thinking of striking out those lines there on 12 through 14 on page 10?
I mean, it was just to, it was not considering the current, people subject to the program, and also it was considering, I think, DOC's testimony about, resources and things like that, but it was to expand the program and limit it to just, those with violation conditions, so those were not, the people currently in it were not considered in the change.
I see. Okay.
What's a policy choice? If we wanted to unstrike that language, we can. But it would have, you say it's a small number, so the cost wouldn't be ginormous then.
I don't believe so. I mean, as long as we're still having a home detention program, I think in the past, I've sat in on testimony in corrections and institutions upstairs where they've discussed getting rid of home detention because it's so infrequently used and costs more money than they see it being worth.
Yeah.
And in each case, the same decision has been made, which is it's an expensive program, but it serves a pretty important
Kind of mark that as a place to come back to their final markup, to determine whether or not we should allow that. I think it's underutilized. And could be a viable alternative if it was not passive. That's the problem. It's passive and they don't like to use a passive home detention.
Understood. We also have constitutional concerns with the rest of that section because it seems to allow essentially what it does is it allows somebody to, just because they were charged with a violation of condition of release, be put on a much more restrictive set of conditions without any analysis of whether or not it's the least restrictive set of conditions necessary to ensure their appearance and public safety. And that's actually a constitutional requirement. Even though that's written in statute in 7554, the Vermont Supreme Court has held, I think it was in State v. Duff, that's an implementation of section 40 of the Constitution. And what they essentially said was, if you use, conditions of release that are more restrictive than are necessary to ensure someone's appearance and public safety, you are essentially punishing them. It goes from being, sort of monitoring and ensuring public safety to punishment before conviction, which is unconstitutional. So that could be fixed very easily. All that it would take would be, to add a line in that simply says, that the court can put,
I'm ready to get that tested.
can place someone on.
Personally, I think it's time to test that constitutionality.
I think that's been tested several times.
Well, time to test it again.
Understood. But our argument would be that whenever the court's making a decision to put somebody on more
Right, I know.
restrictive, conditions, that they have to do so in the way that is the least restrictive necessary to ensure.
When judges stop releasing people that have 1,600 engagements, maybe the public will change their attitude.
What was the line that you were, you said would fix this?
It would just simply be to include something along the lines of, the person charged with a violation of conditions of release, direct post to the court, the prosecutor or defendant. Just in the section where they say that for violating conditions of release, they can put you on home detention, it should simply say, as long as that is the least restrictive set of conditions necessary to ensure appearance and public safety.
Right?
And that would be consistent with
We can come back to that.
constitutional decisions.
We can come back to that then.
So that was page 10. That gets us to page 12 through 15, which is kind of interesting. This is a really very new type of proposal to have essentially a summary proceeding that's not really a criminal proceeding to address violations of conditions of release. And while we certainly opposed the initial versions of this that looked much more punitive and allowed judges to impose days of jail time for conditions of release, this new version, I think with some small changes, we would be able to support. To begin with, on line 11, and this is just a typographical change, it says
Line
arrested.
11 of page 12.
Yes, line 11 of page 12, it says arrested or cited to in accordance with, and I think the to just shouldn't be there. I think that was probably typographical error.
Okay.
I'm on,
Line 10, I think.
Line 10,
line 10, okay, I'm sorry.
where it says rule 3.
I might have the older version of this. I'm working off draft 1.4.
Yeah, we're on 2.1.
This is 2.1. It's substantively the same, but it's gone through editing,
I
so that.
understand that,
yeah.
but we had done this before. Only got 2.1 like yesterday afternoon, so we didn't have.
Nature how it
Sort
goes
of-
these days.
I understood. So we find this process interesting because in the past, violations of conditions of release were not criminalized at all. And so this is sort of reaching back into the past for an old idea of coming up with a non-criminal sort of administrative method of addressing conditions of release. So we do have a few concerns. One is on page 12 on lines 19 through 21, the bill provides that a judge may commence a summary proceeding at an arraignment for violating conditions of release, but that doesn't give the judge any guidance as to which cases should be subject to summary proceedings and which should be subject to criminal prosecution. And we always like to see when we're giving judges discretion that we give guidance along with discretion, because unfettered discretion is just sort of a recipe for geographic injustice. So we'd like to see some guidance there as far as what types of cases should go summary proceeding and what types of cases should go. I see Ben is,
So, this may have been inartful drafting on my part, but it was, the initial appearance was not meant to be arraignment. It was meant to be at the initial appearance where they're brought in to the court after they've been issued that citation, not arraignment for the underlying crime, if that changes your testimony.
understood, and I should have just said initial appearance. I didn't mean arraignment. I meant arraignment just in the colloquial when somebody's brought in for their first appearance in a VOP. But that actually gets me to the next point, which is our concerns about the pace of the summary proceeding. The way that this is set up, someone could come in for an initial appearance on a violation of condition of release and be subject to a summary proceeding that very day, which would not give them notice or time to collect evidence or time to prepare a defense. And that would be a due process problem. And so our suggestion there is to turn that initial appearance into more of a status conference where the court determines first, which track is this going to go on? Is this going to go on the summary procedure track? Or is this going to go on the 7559 prosecution track? And if it's going to go on the summary prosecution track, to determine what time do people need to prepare for that summary proceeding. Defendants need to have the ability to defend themselves. And just the way that our process works, we often, as defense attorneys, would not know that our clients are charged with a violation of condition of release until we show up in court on an arraignment day and find our client waiting in the hallway. And if we have to go right from there to what's essentially a mini trial with no rules of
I'd like
evidence.
to hear from Judge Zone and Tim Waters Dumont on this particular issue of how we get through to deciding what is the alternative sanction to hold somebody accountable besides revoking bail and putting them in jail.
Well, and we think that this is actually a good proposal. We just think that there needs to be
Yeah,
some
no, I
tweaks to it.
understood that.
I would also add, so on page 13, it discusses the hearing and the considerations that the judge must consider for the hearing. And I think those are actually just in the wrong place. The hearing on the merits of the violation of conditions of release, the real question is, has the person violated the conditions of release? And if the answer to that is yes, then the judge has to get into the questions of, have they, what type of violation was it? Is this a repeated violation? What's the nature of the underlying offense? And those are all factors that would weigh into the disposition, not into the merits determination. So we think that those factors actually belong under subsection D, not in the subsection that they're in. On pages 14 on lines 1 through 4, we have the same concerns that we did before, which is it provides a menu of options that the court may impose, conditions that the court may impose if the court finds that somebody has violated their conditions of release. But it seems to allow them to oppose any of those conditions, whether they are the least or most restrictive. And again, constitutionally, conditions of release have to be limited to the least restrictive necessary to ensure appearance and public safety. And that again could be fixed with I think in this one you could replace the words issue any with impose the least restrictive, and that would cure the problem.
How do you? What's less restrictive? An ankle monitor or going away for 2 weeks or 3 weeks to rehab?
Well, that's
I mean, if the
actually,
court says you shall go to substance abuse rehab at Valley Vista for 3 weeks, and I would consider that more restrictive perhaps than an ankle monitor, but.
these are all individualized determinations and judges have to make them. I mean, I've had cases where we've made the argument that certain conditions are too restrictive, just because of where somebody lives and where their relatives live and their access to their relatives.
I'm just saying,
It
I
can
don't
vary.
know, it's in the eye of the beholder, what's the most restrictive thing that you could do.
And that's why we have judges and defense attorneys and prosecutors, is to, in each individual case, make an argument based on the individual before the court.
I don't mind, the language, it's just, I'm saying, it's hard to determine what's, to me, what would be more restrictive. An ankle monitor that tells you that I've had a glass of wine, which is, we now have capable monitors to do that.
And, yeah, I agree with you. It is hard to determine what is the most restrictive and least restrictive
Yeah.
without having the person here in front of you and knowing a bit about, having some evidence about their background, where they live, what their needs are, and how to meet those needs.
Okay. Senator Norris.
Yeah, Marshall, so you don't think that on line 2, the verbiage of reasonably ensure from one of the judicial officers would cover least restrictive?
No, because I think that you could reasonably ensure the safety of the public by taking somebody and sending them to Timbuktu. But that would be very, very restrictive.
Well, then that's reasonable. That's not reasonable.
Yeah, that would be
Well,
unreasonable.
Yeah, reasonably ensure. I mean, we have to give them the
Or-
benefit
or-
of the doubt.
I think maybe you're thinking it would reasonably assure, but it wouldn't be reasonable. So it's,
It's all about which word reasonable is modified.
exactly.
And I think it's important there, and that's part of the reason to use the language of the Supreme
Let's hear
Court
from,
uses.
I'd like to hear from Judge Zone and from, on this particular issue, as well as Tim Waters do on it, how they would see that. But again, your point's well taken, it's just, I realize it's an individual decision, but, I've been around courts enough or around people enough to know what one person considers restrictive, another would consider horrible.
I understand that, and I do think it's just an individual decision, and it's up to the judge and the parties to make that determination.
Okay.
On the same page on line 16, the bill refers to to this proceeding as a prosecution. And I think that's just the wrong word, because Black's Law Dictionary has 2 definitions for prosecution. One is too broad to apply to this. It's the commencement and carrying out of any action or scheme. And the second is a criminal proceeding in which an accused person is tried. This is definitely not a criminal proceeding. If it was, there would be Sixth Amendment rights, Fifth Amendment rights. Proof would have to be beyond a reasonable doubt. This is a summary civil proceeding or administrative civil proceeding. And so I think prosecution is the wrong word, but proceeding would be the right word.
Can I have that green thing, the Germans?
And let's see. And this gets kind of into the weeds, but I think it's important because there's a case directly on point on it, which is that by creating this separate system where there's 2 options for a prosecutor to choose from to either do this sort of civil, non-criminal proceeding that results in changes to conditions or changes to supervision status, or to prosecute under 7559, where conditions of release can be punishable by up to 2 years if it's a failure to appear condition, or 1 year if it's a different type of condition. Creates such a disparity between the 2. There's such disparity in the possible punishments between those 2 options. And there was a case called Miller from the 80s that was addressing exactly these types of questions in the context of violations of conditions of release. And the Supreme Court held that, I'm trying to think how they put it, they essentially held that that it's okay for prosecutors to have some discretion, but giving prosecutors such incredibly broad discretion to choose between, one offense that has a punishment that, in this case, it was 4 times greater than the other offense, is too much discretion, and really just sort of, there's no real guidance as to who gets punished in which way. And so our suggestion for curing that would be to make some changes to the punishments in 7559 such that those are reduced. With those reduced down to, if it was 6 months and 1 year instead of 1 year and 2 years, that would narrow the range from, between those two different options that prosecutors have and avoid any problems with the Miller case. That gets me to page just initially, since we're going section by section, about the electronic monitoring. I think my boss has been clear that we're in support of that. We think that electronic monitoring is an underused tool, and so we are in support of that. That gets us to the pretrial supervision program, and we do have several concerns about that. In particular, on page 18, lines 8 through 14, we think that this is an improper delegation problem. Essentially what it does is allows a judge to put somebody on pretrial, whatever we're calling it, pretrial supervision. And then for the pretrial supervision worker, caseworker, whatever they'll be called, pretrial supervisor, to set conditions, supervision requirements. And then if the person violates one of those requirements, they can be arrested and charged with a violation of conditions of release. And the problem with that is that judges are the ones who write conditions of release. They're the only ones who are allowed to write conditions of release. That's not an authority that they can delegate to the pretrial supervisor. So our solution to that would be pretty simple, which is just to say that judges have to write the conditions, or if they're going to delegate to the pretrial supervisor the authority to set some conditions, they have to do some specific guidance. There's been a couple of Supreme Court cases on this issue in a different context, in the probation context, where judges, for example, have written probation conditions that simply say, abide by all directions given by your treatment provider.
Right.
And the courts have struck those
I've
down
seen
and
those.
said, you're delegating too much authority to them to essentially create a condition. And this is actually more serious because instead of creating a condition of probation,
The court could require the pretrial supervisor to notify the court if the person is not participating.
absolutely,
And that would be a better way to do it.
I think that would be a better way to do it. Yes.
That's actually what I think we had in mind.
Where are you seeing that the pre-trial supervisor is the one who would write or issue the conditions, or am I misunderstanding?
Well, I suppose I'm inferring that from the fact that there's nowhere that it says where the supervision requirements come from. And all it says is that pretrial supervisors shall notify the court that placed the person in pretrial supervision program of any violation of the supervision requirements committed by the
If
person.
the court, my understanding of how it would work, the court places the person into the pretrial supervision with the order to the pretrial supervisor that they report any violations to the court.
Yeah.
I think that would work
Lack
as
of
long as
participation or whatever.
as it's the court setting the
The court is
conditions, not
setting
the
the
pretrial
condition, not the
supervisor.
pretrial supervisor.
Absolutely.
I'm fine with clarifying that. I felt like it was a given, but I mean, if clarifying it helps, then fine with that.
So we also have some concerns about the eligibility requirements. One of them is the one that you raised, Senator Sears, has the ability to make or receive phone calls. We think that's not only a problem with the lack of self-service in Vermont and, in fact, even the lack of landline service in Vermont. I mean, at my house, when the wind blows too hard, the landline stops working. And also, we think it presents some ADA problems. There's some people who are deaf or hard of hearing and can't make or receive phone calls in the traditional sense. And we also have concerns because it doesn't specify has the ability, like what does has the ability to make or receive telephone calls mean? Some concern around language access that if this is going to be interpreted to mean can make or receive phone calls in English, that would be problematic.
Well, if it said the department supervision methods may include,
Understood.
that would be better than shall include.
Yes.
That's on line 1.
We also have concerns with the requirement that this is only eligible for Vermont residents with Vermont addresses. People come to Vermont from all over the place. If they commit a crime in the state of Vermont or are accused of committing a crime in the state of Vermont, they should be entitled to the same protections and services that Vermonters are entitled to.
I agree.
And it's, from my perspective.
Thinking of the woman who, from Vermont, who gets caught in New Jersey and is doing phone monitoring with New Jersey in order to complete her requirement. She's being supervised by New Jersey. I'm not sure which agency it is in New Jersey, but it's pre-trial. So she should be able to do that. Somebody from New Jersey should be able to do that in Vermont. I agree.
Would there be an issue with, this person's back in New Jersey and then the pretrial supervisor having to determine if they committed a crime or violated their conditions in New Jersey, as opposed to whether or not they violated their conditions and violated Vermont law or their conditions in Vermont? Is there an issue there?
I can say like certainly would be more difficult to supervise somebody who's out of state than somebody who's in state. But I think we have to make a provision to allow it because we don't want to treat people differently just because of what state they're from.
In the case that I'm thinking of, she was required to enter into drug treatment. They have the notice that she did and she completed that. She has a requirement of urine samples every so often. I don't know how often. She is meeting that requirement. They check that. So they're supervising what they can. Obviously, they can't supervise everything, but she at least is able to not be incarcerated with all that would go on there. She's being monitored.
Which seems very appropriate.
Yeah, so I think I don't have a problem with it. Obviously, the court still has to make the determination whether they're eligible according to, whatever conditions are set. Senator Sheen.
So one more thing. So page 18, line 9, court may issue a warrant for the arrest of a person who fails to report to the pretrial supervisor. Maybe I'm splitting hairs here, but if somebody's back in New Jersey and they're not reporting to their pretrial supervisor who's in Vermont, are they violating Vermont law while in New Jersey and therefore the judge can issue a warrant for them while they're in New Jersey?
I don't think a judge could issue an out-of-state warrant for a VCR. I'm looking back at Judge Zone to verify that, but I think an out-of-state warrant requires some level. I'd have to look at the out-of-state warrant requirements.
Courts Tom Zone, Chief Superior Judge, we issue a warrant, and if it can be exercised out of state, that's up to the parties in the other states. We don't issue in-state or out-of-state warrants. De facto, if we do arrest somebody and bring them to court, that's not going to be executed out of state. But, in terms of warrants, we issue the warrant, and what the state is able to utilize it with under any compacts is up to the state.
Thank you.
So finally, I would just say the last comments on this bill, are near the very end. And that is on page 24, and I think my line numbers are off from the original, so I'm looking at subsection D, which says conduct constituting the offense of using a firearm while selling or trafficking a regulated drug shall be considered a violent act for purposes of determining bail. And our concern with that is that there's rules of constitutional interpretation. And the first one of those rules is the supremacy of text principle, which says that the words in the Constitution mean what they mean, and they can't be expanded upon or contracted by judges of the legislature.
Court of the United States that yet?
Well, they're the only ones who are allowed to mess with it. Legislatures can't. And that's really the point, is that the purpose, and this is actually quoting from a Supreme Court case, is the purpose of the term must be derived from the text, not from extrinsic sources such as legislative history or an assumption about the drafter's desires. The text of section 40 has been interpreted clearly. It says that a court can hold a person without bail for an offense, an element of which involves an act of violence against another person. The legislature can't sort of create an act of violence against another person by defining the act of trading a gun for drugs as violence against another person.
We already did that. Made that against the law. This language comes from that section of the law that we did last year in S4.
Certainly, and the court can make it against the law to trade a gun for drugs.
Well, we did.
But what you can't do is say
It's a violent crime?
A crime with an element of violence against another person for purposes of bail.
Well, I think it is.
I understand that, but the court's been very strict about its interpretation.
Well,
And in fact, that gets to the second of the
Well,
two principles.
I think we should test the court.
The two principles of
Because I
constitutional
think the court
interpretation.
is wrong. If somebody's holding a gun in my face, whether they shoot me or not, it's still pretty violent to me. I don't think that's a non-violent crime, and that's the using the gun. Even if they're placing it on the coffee table, and I'm seeing the gun there, and I'm saying, well, what should I do? I'll do whatever they want, I guess, because they can shoot me.
I'm not suggesting that the court.
That's violent.
I'm not suggesting that the court would not find that to be an act of violence. I don't think the court would find the exchange of firearms for drugs to be an act of violence.
We did that last year in S4.
But that's included
Am I missing
here.
something here?
So I'm looking at
I'm
subsection.
missing something, because S4 made that a crime,
Yes,
to trade guns for drugs.
yes.
And now you're saying,
What I'm reading from subsection C, and it's a definition, and it says, for purposes of this section, use of a firearm includes using a firearm while selling or trafficking a regulated drug, and the exchange of firearms for drugs, and this section shall apply to a person who trades a firearm for a drug and the person who trades a drug for a firearm.
yeah,
And then the second section, subsection D, says conduct constituting the offense of using a firearm while selling or trafficking a regulated drug shall be considered a violent act for
I
purposes
guess
of
you could
determining
ask
bail.
that lady in St. Johnsbury who just got killed by the 15-year-old.
I don't think that there's any doubt that that would be a crime with an element involving an act of violence against another person.
We use the term using so that it wouldn't cover somebody who happened to have a firearm in the trunk.
I understand that, but it does cover trading firearms for drugs.
Senator Hershey.
Yeah, I think maybe this will clarify it, but I think that what you're referring to, Marshall, is at the very top of page 24, which states explicitly the exchange of firearms for drugs, as compared to the next section below which starts on our line 4. Or I'm sorry, let me back up a little bit. Using a firearm while selling or trafficking a regulated drug. So it's actually earlier on page 23. And so there's that differentiation between using the firearm, such as the example of, pointing it in someone's face, which I do think would be violent, versus the exchange, which I think you're describing as trading a gun to receive drugs, which doesn't have an element of violence in it. So I think there are two different pieces there.
Correct.
Senator Ben.
Well, I think, yes to that, but I think really the heart of what Marshall is getting at is just by determining that such conduct is a violent act itself, especially when you're tying in the determination of bail, you can't do that in statute. It's that it has to really, it's a constitutional mandate, not statutory.
My recollection is this came from the governor's office, and I'm assuming that the governor's legal counsel knew what was constitutional, knew what wasn't.
A proposed change maybe, I don't know if it completely cures the issue, is striking for the purposes of determining bail.
Yeah, but S4, it says exactly that.
I'm not as familiar with
It
that.
says,
Yeah, it's like the same.
it is to prohibit the possession of firearms by fugitives from justice, persons subject to final relief from abuse orders, stalking orders, and persons charged with human trafficking a regulated drug, or carrying a dangerous weapon while committing a felony. That's the biggest difference, and it said this can be used to determine, for determining a bail, which I thought we already approved in S4.
We take your advice and move on. Yes, Senator.
And maybe this is in a different section, but I'm on page 21, lines 6 through 9. Under orders, it says the court may only revoke bail upon a finding that a legitimate and compelling state interest exists. The court shall not revoke bail based on a breach of conditions of release alone, or solely because the accused may endanger the public. But am I right that someone who might endanger the public, who has also breached conditions, could have their bail revoked?
If they meet all the other conditions that are in the first section or one of the conditions in subsection A.
So in other words, I know that you can't revoke bail just because of threat to the public or potential threat to the public. But what we're saying here is, if they have then breached conditions in addition to that potential threat, then you could revoke bail.
As long as their breach of conditions or their threat has in some way inhibits the judicial process as described in sections A1 through A5. And that's all drawn from, there's a couple of cases, Gates and Small. And this language, we had no concerns about this language B, C, and D because it's essentially identical to the language in Gates and Saul.
I have to say, that's something I have a real hard time with, the idea that someone might be a clear threat to the public, but you couldn't deny bail.
And that honestly goes back to the 1993 discussions in this committee.
Yeah.
About what the constitutional amendment meant and how the Supreme Court.
Yeah.
In the first case, I don't remember the case, but in the first case that came up as a result of the new bail constitutional amendment, that's where the court made a decision.
And just to explain it further, in those cases, it's really if the conduct creates a palpable threat to the integrity of the judicial system. So what the rationale was is that just because someone may endanger the public doesn't necessarily mean it would threaten the prosecution itself.
Right, but that seems to me just on a philosophical level, to place the integrity of the judiciary over public safety.
Yeah.
And saying, well, if 4 or 5 people got killed because this person was released, that's not as serious as if it would inhibit the judicial process. I don't agree with that. I think they're at least equivalent.
Can you look at what that case was in '93?
Yeah, I believe it was the Soto case.
I think it was.
Yeah. But and Senator Ruth, to your point, if, you know, if they did endanger the public by killing someone, then, not to eat my own words from yesterday, 7553 and 7553A may come into effect at that point. They could be held without bail because it's either life imprisonment or violent felony.
Well, but then we got a dead person. So I guess what we're trying to prevent is the killing.
Yes.
Right.
Laudable goal.
That's a lot of people.
And all I'm saying, Marshall, is I don't disagree with you, because we either got it wrong in both places.
Can you give me a copy of that?
No, I understand that. That's,
I just
some
like
of what
it.
I did here, I cut and pasted from my testimony about S4. So, if there's no further
Appreciate
questions.
your thorough
Consistency.
overlooking of this. Our next witness is Timothy Lotters. Dumont has been patiently waiting. And I'm wondering, we're gonna take a break at some point and hear from Judge Zone. Judge, are you on a time?
I am not.
Okay, good. So Tim, if you could give us and then we'll take a break.
Yes, Mr. Chair. Tim Leaders, Department of State's Attorneys and Sheriffs, and I wanted to start with jumping to the middle of the bill very quickly, just because I wanted to echo a point that Attorney Paul made that I thought was apt, and when I was reading through it, he put it better than I think I could. But the practice point about bringing the person in for the summary proceeding, if you look on page 12, 7554E, I think it's a really good point to note that at that point when they're coming in, let's call it the initial appearance, that's where there's the discussion that can take place about whether the judge can say, do you want to go down door A, which could be the summary proceeding pathway, or does the state want to pursue a violation of conditions of release for criminal contempt, which is the existing piece? I think that is I agreed with Attorney Paul's point as to that. I think that's an important practice point because it also accomplishes the goal of making sure that a prosecutor and a judge don't get confused and accidentally start pursuing both pathways, which the statute doesn't allow for, doesn't intend to allow for. So does that make sense? I wanted to echo Marshall's point on that. And also, we rarely get to agree on points with the Defender General's office. So I thought that was another positive point. Looking at the home detention provision, generally, we're very supportive of any expansion of home detention. So appreciate that this bill in general, I think, tries to provide more options, and that's good. And when you're actually exercising an existing option in a way that's good as well. One concern upon consult with a few of our folks this morning was, instead of having it reference, and Attorney Novogrowski and I could chat about this further offline as well, because I definitely appreciate that this bill should keep moving. But if you're looking at pages 10 and 12,
3, page 10, right?
Tim, what
yeah.
section are you talking about?
Oh, I'm sorry, Senator. Pages 10 and 12, talking about the home detention program.
On page, section 3.
And from here on, I will proceed in more chronological, but I wanted to start with the point that Marshall had made. So looking at pages 10 and 12 about home detention, there's a reference to 7575, which is the revocation statute. I think one way to accomplish the goal of better utilizing this while still having some of the existing pieces in play, instead of expressly only mentioning 7575, if I'm reading it correctly, you could also provide that let's say someone violating home detention could also trigger this summary proceeding as well. You could now go back in what I'll call it escalation as well, as Attorney Novigrowski did. Or it could trigger another bail review. So the judge could say, we're coming back in, we're going to talk about whether bail should be imposed or whether other conditions should be imposed. That way it gives kind of three options. Yes, you could try 75-75, the revocation, but maybe also this new escalation for VCRs, and also the regular bail review under 7554. If that makes sense, Attorney Novigrowski, I'm kind of looking at you, but provides that menu of options that are also in existing law while still expanding home detention. And I can certainly follow up as to how to accomplish.
Yep.
And then I also wanted to note, just as a procedural point, and I believe Attorney Paul may have made reference to this in some way, that as to home detention right now, one of the pieces that allows it to work, but also one of the reasons why it's such a limited tool at the moment, is because it only applies to the imposition of bail. So people have monetary bail imposed on them, which is why they were eligible for the program. That's why it's like the fishnets. They've gotten through the initial phase, which is, yes, they have bail imposed. And then there's been this analysis that home detention may be helpful to them. And so if bail is not imposed, which is contemplated here, and they're on home detention, there isn't that immediate mechanism to return. And so that's why having them come back to court is an important piece, so you can sort out where the individual will either be supervised, et cetera. And so providing that, because there isn't going to be bail imposed on all the individuals on home detention, if that makes sense. And if I'll pause, feel free to speak up if there's any questions.
No.
Okay. Moving along to, I think you've talked about a lot of important points about electronic monitoring and pretrial supervision. I don't have much to say on that. I think you're all sorting through the issues on that. I did want to make a note about the misdemeanor docket. I certainly appreciate the efforts there because they don't have anything negative to say about that. That's on page 25 towards the end of the bill. We've been talking about something resembling that for a while now, and I think my overall comment on this bill, as reflected on the misdemeanor docket section on page 25, there's going to be some things we have to work out in this. We might have to come back and tweak things. Things may get tweaked in other manners, but I think what you're trying to do here is provide more options on the landscape of individuals who are struggling with the conditions, and building upon this infrastructure in the future, I think will be helpful. But I did want to also note that, as I know we've discussed in Senate Appropriations, Mr. Chair, that increased resources to actually prosecute and reach disposition, reach the final ending point for these misdemeanor dockets may include the need for more defense attorneys in addition to more prosecutors. And we appreciate the efforts.
It may involve that, but I have a sense that if they got started, it would zoom, to use a phrase, you're on Zoom now. I think it would zoom through people would settle rather quickly some of the misdemeanors that are hanging out there that are not very serious, but then they're picking up violations and other stuff. And I think you would get rid of a lot of cases that would settle quickly. So then it may require more resources up front, but later on, those resources would either not be needed or could go somewhere else. I just think it's there, a misdemeanor is the misdemeanor, so it doesn't get the first hearing. And we delay for 7-8 months, and the person, it's hard to stay good for 7 or 8 months if you're prone to certain behaviors. And then they pick up violations, and people say, "Oh my God, look what's happening." But
right. So yeah, I think that was really, the most of the substantive comments I think you've already really talked about, and certainly I always appreciate hearing from Judge Zone, who will have some time. But if this moves along, don't be surprised if there's things that we identify, you know, down the road that need to be
No, we fully
ironed out,
expect
as I said.
when it gets to the other body that it would be, gone through and there may be changes that they see, but the goal here is clear, is to deal with violations of conditions of release, but also to have better outcomes for people that are accused of certain crimes. I wonder if you wanted to comment on the gun thing, which came into
I was
making
hoping
that
that my time would run out and you wouldn't ask me that. But I tend to agree with you, Mr. Chair, that it can be sorted out by the courts and see where that falls. I was not prepared for my oral argument this morning, so I'm not sure I want to weigh in too much on that. But I think there's often things that have to be sorted out through litigation, and that's not wholly unhealthy.
Okay. Other questions for Tim? Tim, thanks very much for making time.
Thank you, Mr. Chair.
If it's okay with Judge Zoney, we're gonna take a 10-minute break and then come back at 10 of 12.